Hi, my name is Goldman, and I'm an attorney with Goldman and Associates. And today I'd like to talk to you about guardianships. It comes about because a lot of times people need to take care of somebody else, and half the times we'll get a call, my parents or my mother, my father, one of them has dementia. They get confused. They're suffering a little bit. They're experiencing cognitive difficulties. I want to do a power of attorney just in case. Well, ladies and gentlemen, a power of attorney is not for someone to give if they have dementia, okay? One of the first lines in your standard power of attorney bespeaks the fact that they are of sound mind and body. The moment somebody has dementia, they can't do a power of attorney. What has to happen? You got to get guardianship over them. And there's a big difference, cost-wise and procedure-wise, between a durable power of attorney and a guardianship. Just to give you some rough numbers, power of attorney, most law firms will do a durable power of attorney for about $300. Guardianship's going to cost $2,500. Huge difference. So if you want to take the appropriate steps, do it before the person shows obvious signs of dementia, because then it's too late and then you got to go through guardianship. And how do you go through guardianship? Well, it's a probate proceeding. It's much more expensive because it's much more involved. You've got to file a petition to commence proceedings in the probate court and tell the court this person needs a guardian. And here's the medical substantiation for it. And here's what we want to do. And the court will do a couple things. Number one, the court will set up a hearing to determine A, does the person need a guardian? And B, are you, as the petitioner, a suitable guardian? You may be or you may not be. In order to establish this, the court may dispatch a court functionary, sort of a non-judicial functionary, typically a lawyer, and that's a person called the guardian ad litem, someone appointed by the court to go talk to the person, see how they feel about having a guardian appointed for them, see how they feel about the proposed guardian, and get a sense of whether or not that person needs the extra help. And that guardian ad litem writes a report to the court, recommending or not recommending the guardianship, and recommending or not recommending the proposed guardian. Now sometimes they'll say, the person doesn't really want a guardian, but all things considered, I feel that the person would benefit from the help. And in that case, the court will typically appoint a guardian. But the question then becomes who it is. When you have multiple children, for example, many times one sibling will say, I'm okay with mom having a guardian, I just don't want it to be Jim. He's been stealing from her for years. I just don't want it to be Sarah. She's no good. She's not reliable. She's on drugs, whatever. There may be strife within the family as to who should be the guardian. So in a situation like that, the court has options. The court can appoint multiple sort of co-guardians. The court can decide one over the other and pick one guardian as opposed to another. Or the court can say, the heck with all of you, I'm going to appoint my own guardian. And that could be a service, it could be a lawyer, it could be somebody that the court trusts to make sure that the interests of the ward are protected. If you have any questions about that, give us a call, and of course, we'll be glad to help you out. If you have found this helpful, please like and share.